Good afternoon, California. My name is Trey Delap, and I am a We the People alum. I was a student that got to participate in nationals 1,000 years ago. That's my computer letting us know it's 11 o'clock. Otherwise, I am a lobbyist working in Nevada, and I also am the executive director of the Nevada Center for Civic Engagement, and we inherit the We the People program as long as other civic engagement programs. And I'd like to invite my colleagues to introduce themselves.
So, good morning, California. My name is Lynn Uzel. I'm a native Californian, now living in Virginia and teaching American politics at the University of Virginia.
I'm Lindsey Draper. Okay, to the extent that we want you to know our connections with California, my siblings are all in California. They all think there's something wrong with me living in Wisconsin, but I am retired from the juvenile court bench in Milwaukee County, Wisconsin, former chair of the State Bar Association Law-Related Education Committee, the seat of the We the People competition in Wisconsin.
And that's us. And now who are you and who's your teacher?
Good morning. We are Foothill High School's Unit 2, representing the state of California. My name is Dylan D'Amico.
My name is Allison Lee.
My name is Chloe Talari.
My name is Alex Shen, and we would like to thank the judges, the timekeeper, and the audience for being here today, as well as introduce our coaches, Mr. Dedamore and Mr. McBride.
Excellent. Well, let's get to it. We're all here to answer the question number 1, which I hope you're familiar with, and I will read it for the record. Number 1, the states sent delegates to the Philadelphia Convention to join with other states, quote, in devising and discussing all such alterations and further provisions as may be necessary to render the federal Constitution adequate to the exigencies of the Union, end quote. To what extent, if any, did the delegates follow their instructions? What experiences of state governments under their new constitutions after independence might have influenced the creation of the Constitution? Do the decisions of the U.S. Supreme Court function as a continuing constitutional convention? Why or why not? And please begin.
On January 21st, 1787, the Confederation Congress passed a resolution stating that the goal of the Philadelphia Convention was for the sole and express purpose of revising the Articles of Confederation. Yet, the framers abandoned the Articles, creating a new government instead. Though the framers violated the rhetoric of their mandate, we believe they followed the intent of their mandate for 2 main reasons.
First, the delegates followed instructions to render the government adequate to the exigencies of the Union. They fixed the flawed Articles of Confederation by giving Congress the power to tax and regulate interstate commerce in Article 1, Section 8, and allowed the executive to be Commander-in-Chief of the Army and Navy in Article 2, Section 2.
Second, the delegates followed the spirit of their mandate as Congress's resolution on January 21st, 1787, stated
that the delegates' proposals had to be reported to the state legislatures for confirmation. The delegates followed these instructions as seen by the inclusion of Article 7 in the Constitution that required 9 out of the 13 states to ratify the eventual Constitution. After independence, the Philadelphia Convention delegates looked to precedents, using experiences with the successes and failures of early state governments as guidance for the creation of the Constitution. These experiences were felt in all branches of government.
First, representative election in Massachusetts influenced the indirect election of senators. During the Philadelphia Convention, Elbridge Gerry argued that Massachusetts' direct election allowed ignorant representatives and even criminals to be elected. Fearful of such impulses, the framers called for election of senators by state governments instead, through Article 1, Section 3 of the eventual Constitution.
Second, the judiciary was prone to corruption because jurisdiction was never clearly outlined in state constitutions. William Livingston, the governor of New Jersey, exploited the vagueness regarding the judicial branch and forced courts to rule a certain way based on bribes he received. Thus, the framers created Article 3, limiting the courts to act within their jurisdiction and limiting the executive's influence through this check.
Third, the fragility of executive power influenced the creation of the executive branch. Many early state executives were exceedingly weak, like Pennsylvania, which had no executive, but instead a council that highlighted the legislature's dominance. This council was prone to corruption due to the legislature's influence, resulting in only the legislative agenda being pushed.
To combat this, the framers looked to states with the successful executive as an example. Specifically, the framers drew from Article 18 of the Constitution of New York, giving the executive branch more enforcement provisions.
When establishing the qualities of a constitutional convention, we define it as a meeting that creates or amends the structures and limits of government authority. Because the court only interprets the existing constitution's meaning rather than drastically redefining its structure, we do not believe the court functions as a continuing constitutional convention. Unlike a convention where ideas are easily proposed, the court is generally bound by stare decisis.
The Supreme Court was not designed to legislate from the bench, but rather to interpret the existing language of the Constitution. In Federalist Essay number 78, Alexander Hamilton argues that the Supreme Court is the least dangerous branch because it is bound by the Constitution and is thus unable to enact large-scale change.
However, the Supreme Court has played a significant role in helping our nation progress and have overturned precedent in extreme cases. In Brown v. Board of Education, 1954, the court overturned Plessy v. Ferguson, 1896, by striking down the separate but equal doctrine as it violated the 14th Amendment's Equal Protection Clause.
But this is still different from a constitutional convention where every state's interest should be clearly represented. Even in modern state constitutional conventions, the delegates are elected by the people. The 9 Supreme Court justices are not enough to express all of the different states' opinions, however, as they are not elected by the people. Thank you.
Thank you. And I just want you to know that technical glitches are to be understood, so there's no harm, no foul in that. So I want to pose a question. It seems like we want to establish whether or not the court is or is not a convention. What would happen if we just didn't have a mechanism to alter the Constitution without a convention or other ways of changing it?
I believe that the amendment process really has a good way of changing the way the Constitution is without a convention. You could see that even as it requires 37 out of the 50 states, there's a large majority of states that have their voices and opinions represented through these amendments. And usually these amendments are pushed through times of crisis, and this amendment process has really allowed the Constitution to be a living, breathing document.
And I think the framers recognized the need for the Constitution to be able to have amendments added later on. And I think the framers really looked to some states, for example, Massachusetts, which was one of the few early state constitutions that had an amendment process where they had a mechanism of changing it without having a new convention every single time they wanted to make fixes. So because of that, they established the amendment process in Article 5.
Okay, unmute. I also wanted to ask, because I wondered if your stance that the Supreme Court does not function as a convention because they only interpret, I wonder if you are creating a sort of tautology by proving by definition. So what I want to ask is it even possible for the Supreme Court to interpret the Constitution in such a way that they do change the meaning of the Constitution? Is that possible? And if it's possible, is it legitimate or not?
Well, I think the way that the Supreme Court could do this to an extent is looking to the penumbras of the Constitution and finding rights that aren't explicitly stated there, but instead implied. And I think that by doing this, they can, in a way, change the meaning of the Constitution. And this can be shown through cases like Roe v. Wade, where they, looked to the right of privacy that wasn't explicitly enumerated, but was still there in the penumbras to kind of change the meaning in a way.
But to add on to what Chloe was saying, I don't think this change is as legitimate as it should be, because we've seen that these controversial issues such as abortion and these controversial issues such as abortion are often left to the bench to decide because the legislative branch typically fails to actually enact bills that represent the majority of the people's interests. So I don't think this is as legitimate as it should be.
When you say it is not legitimate,
No.
you think that that when the court acts like that, it's not legitimate? Is that what you're saying?
Yeah, like the court enacting the change.
Mm-hmm.
I disagree. I personally think that in that decision, specifically Roe v. Wade 1973, I think that this was legitimate, and because although some people may claim that it is judicial activism, I think that they were able to interpret the Constitution and specifically the Fourth Amendment in a way that was applicable to the current times and the needs of the American people. So I think that as long as the court is still able to cite a specific part of the Constitution and explain why that specific language of the Constitution is able to apply to the current situation, I think that it is justified.
In your statement, you indicated that the Supreme Court differed from a convention in that every state is not clearly represented as they would be at a convention. If I were to posit to you that I don't disagree with you, but Rhode Island wasn't represented at the Constitutional Convention, and even though the articles insisted that they be there if there were going to be an amendment, people kind of said, so let's do it anyway. Does that make everything that came thereafter illegitimate?
I do not believe that just because Rhode Island was not there to give their input on the Constitution, I believe that the document is very much legitimate, as they did have to submit the document to the states to actually be ratified. It had to go through state ratifying conventions where it was heavily debated and had many amendments that were proposed at these conventions, and how it eventually turned into the Constitution. Even with Rhode Island not being there, they still had their input later on after the Constitution was created.
And I agree with Dylan, and I think because of Article 7 of the Constitution, which required 9 out of the 13 states to ratify the Constitution, I think this did show that the framers were willing to have outside opinions kind of be able to decide from themselves with the state ratifying conventions to give their input. And although not every state, with Rhode Island being there at the convention, Rhode Island did eventually ratify the Constitution later.
And I think this was legitimate despite Rhode Island not being there, specifically because Rhode Island was given the opportunity to actually show up at the convention and be represented. However, they voluntarily chose to give up this representation. So I don't think that it would be illegitimate in the sense that the framers ignored what Rhode Island said, as Rhode Island voluntarily gave up their right to be represented.
Maybe that was their way of saying we don't want anything changed.
There was many states actually during the time that were really thriving under the Articles of Confederation, such as New York, as they were able to pose taxes and all this other stuff. Oh, may I finish my thought?
Go ahead.
As they were able to flourish under the Articles of Confederation, although they knew that the Union would be far more successful under a new constitution.
Excellent. Yay. I very much appreciated your presentation and your response to the question. I think what you set us up for in your prepared statement was a lot of opportunities for a robust discussion, and I really do appreciate the amount of time you gave to each part of this question. And I think this one is especially tempting to hyper focus on certain issues, and so I think laying it out in this way was interesting. What I'm looking for in this question is the moral authority to ignore the law. And this question ultimately is asking, when and how is it okay to reject the rules? And, the Declaration of Independence laid out the conditions for rebellion, sort of as a piece. Now, is that an enduring document forever? I don't know. But when, this is very interesting because, the time that we're looking at was, and the other key detail of this question is the exigency, the urgency, the necessary component. If things weren't so awful or terrible, then we do have more justification to override things. So I think that your group did a good job of presenting a variety of things, and we could go deeper in them. And I found that when we queried into some deeper bits, that you did have more information. So that's always a good sign when we leave a lot on the table that we would like to talk about. So thank you very much for your work.
I want to reinforce what my colleague said. Your opening statement was, I thought, especially strong. It was very nuanced. It covered deeply into all three aspects of these questions, and all three of these questions were very broad. And then with such a strong opening statement, I kind of hit you hard with a pretty challenging question as to whether or not your answer on the third question was a tautology or not. And I thought that your response overall was very good, even though you came from different directions. You were able to meet that challenge, and I thought I was throwing you a pretty difficult one, but you were ready for me, and you were ready to come back swinging. So I appreciated both answers that you gave, even though they were coming from different directions. And I thought in general, that's the way that you answer these questions, is that you have individuals answering the question, and they're coming at different directions, and that each one adds something else. So I thought that's one of the reasons that made this a really strong round.
I don't know that my comments are going to be a whole lot different than anything you've already heard. That you laid out in a very defined order your answers helped me visualize what I should be listening for. And it strengthened the fact that, these questions are incredibly broad, all three of the parts of it. And you've only got so much time to get your answers in, and you made it very clear that we can tell you which specific states, we can tell you what principles, and we can also tell you why some things happened. I got really, really worried when you talked about the court being bound by stare decisis. I'm going, uh-oh, I'm going to have to talk to them about Plessy v. Ferguson. And so I was really pleased when you said, and by the way, I know what you're waiting for. We got you, Brown. I was really pleased you did that. I mean, so excellent. I enjoyed it very much. Thank you.
Thank you.
Thank you so much.
Yay again.